do have the agenda before you. The chair would entertain a motion to approve the agenda. Have a motion, is there a second?
Second.
Motion and a second. Any further discussion? Call for the question. All those in favor, aye.
Aye.
Opposed? Recused. All right. Also, we have Mr. Brian Smith with us, who will be acting as the hearing officer. Chair would entertain a motion to approve that as well.
So moved.
Have a motion, Mr. Locklear, second.
Second.
Mr. Sermons, any further discussion? All those in favor, aye.
Aye.
Opposed?
Recused by David.
Okay. All right. And at this point, I'll turn it over to Mr. Smith.
All right, thank you very much. Again, my name is Brian Smith from the law firm Hartman, Hartley & Hawkins. I'll be serving as the hearing officer at this hearing today, and ruling on objections and legal matters. This is a hearing over a complaint and grievance procedure filed by Ms. Lisa Strickland involving the superintendent and associate superintendent of schools, Mr. Keith Humphrey, and his wife, Kathy Humphrey. I understand there's going to be some preliminary issues that the parties have, and I've got a copy of a couple of motions that we'll address in a moment. Just for the record, and we'll get everybody kind of seated around the table in just a minute to hopefully be somewhat organized. But can I get, at least for the record, who is here on behalf of Ms. Strickland and as well as the Humphreys?
Brad Wilson is here on behalf of the Humphreys.
And Chris West is here on behalf of Lisa Strickland.
And we met briefly before to discuss procedure, but at least as far as evidence and presentation, we'll begin with Mr. West on behalf of Ms. Strickland, who will present their evidence and information first. And following that presentation, Mr. Wilson on behalf of the Humphreys will present any evidence and information from their point of view. At least initially, I understand, Mr. Wilson, you have a couple of motions that you wish to make from a preliminary standpoint regarding the hearing.
That's correct. You ready for me to proceed with those?
Absolutely.
Okay. The first motion is a motion to disqualify or recuse Mr. Strickland from this matter since his wife is the complainant in the case. And we've already filed with you the motion itself, which would prevent him from participating in any deliberations, involvement at all in terms of the hearing itself, and also participating at the table here with the other board members.
And Mr. Strickland, I ask you, you understand the motion?
Yes, sir, I do.
Statement of what you're being asked. Without having to have me rule on any of it, what's your inclination as far as participation in
I
the
don't
hearing?
mind removing, I just wanted to put that to you to make sure that's the case. I understand I can't vote or deliberate.
Correct, correct. I believe that's the motion. Non-participatory as far as this hearing is concerned.
Sure.
Certainly makes sense in light of the relationship. And voluntary recusal is certainly appreciated. It may be easier, and I'm trying to figure out how to fit everybody in. If we can try to get all the board on one side of the table and then have the party sit on the other, is that? Just at least so we can have people close together, the reporter will be able to pick it up a little bit more easily, and certainly the board can hear the witnesses speak. And if you decide everybody, but however y'all want to work out sitting around the table.
You can have a chair there.
I think that resolves the first motion.
Yes, sir.
Second was the dismissal motion.
Yes. I'll cover that. I've already filed the position with the hearing officer, but I'll just review for purposes of the board the contents of our motion to dismiss the case. First of all, when you look at the grievance complaint that was filed, you've got a specific board policy that already addresses the issue of grievances and procedures and all that have to be followed. The basis of the motion to dismiss is there are two allegations set forth in the grievance. The first one was it was not until May the 3rd of 2013 that Ms. Strickland received her notification of the assignment of a job contract. That's point one. The second one, she was complaining of 2 of 43 performance responsibilities referenced as being under the supervision of the federal programs director. The other statement of fact was that the policy for the Lanier County Board of Education is that a grievance has to be filed within 10 days of the event. The board, as you're aware, voted on this and approved her contract back in February the 28th. So we've got a number of reasons why this matter should be dismissed and no evidence needs to be presented, because as a matter of law is an untimely filing. The vote to put her in her new position was February the 28th. The policy specifically says you have to file it within 10 days of the event. It is based on when the event occurred. The filing had to be within February 28th. The second point that she raised was she got notice on May the 3rd. Well, looking at all of this in terms of the context, she states that she was not aware of her job assignment until then. She acknowledged that she was aware of the transfer to the lead teacher position back on February the 28th. Vote was taken in public session. It was published in the newspaper. It's in the board minutes. In addition, on March the 6th, an article appeared in the Advocate in which, and we've attached it to the motion, it stated the transfer of Lisa Strickland to instructional lead teacher was approved by the Lanier County Board of Education at its meeting on Thursday. And interestingly enough, not only the complainant, but also her mother were interviewed about the motion and the transfer. And both of them referenced the transfer. So there was actual knowledge of the transfer by Ms. Strickland, clearly in publication, on the night it occurred and published in the newspaper on March the 6th. So there's no question about having the actual notice and the clock start ticking. It was not a matter of this was something done in executive session and there was no disclosure to the public or to Ms. Strickland at all about this occurring. The next thing you look at is her second aspect of the complaint was knowledge of duties and responsibilities. And that's clearly unfounded. The job description, as far as the instructional lead teacher, was modified back in October of 2012. It was revised at that point in time. It's been online since that time. She failed to disclose to you in the fact in the grievance that she attended the leadership meeting back on October the 3rd, in which the duties, the responsibilities, and also the job description was discussed at that leadership meeting. I've attached to the motion the sign-in sheet, which shows that she was there on October 3rd when that meeting occurred. And it detailed what had happened. Next, on December the 5th, there was another system improvement team meeting. We've got that attached as an exhibit with the sign-in sheet when Ms. Strickland was present, which also covered duties and responsibilities. Further, on January the 9th of this year, there was a system leadership meeting which occurred, which focused on professional learning and instructional support specialists. So you got monthly meetings coming along which clearly detailed all the duties and responsibilities of an instructional lead teacher. She was well aware of all the duties and responsibilities and who at all times supervised that position. On the report on the duties and responsibilities which we've attached, it clearly shows that the individual responsible for supervision of her is the associate superintendent. Likewise, in the correspondence that was sent on March the 11th of 2013, she requested job descriptions from Becky Moore and also from Ms. Humphrey, which was provided. That occurred back in March. Finally, the thing that you also need to know is that as a central office administrator, they have full access to all information and are applicable to the consolidated application program. where you just log in and you pull up the job description of every single administrator. So all of this, there's no way that Ms. Strickland can contend that she didn't have actual notice, which has been readily available since October of 2012, as to each duty, responsibility, and who is responsible for supervising that position. In addition, she has worked closely with Ms. Humphrey for the last 2 years. She knows that Ms. Humphrey is the individual who supervises instructional lead teachers and has for the last 2 years. We've also outlined in here another basis as far as failure to state a claim for this. She was offered a contract. The vote to approve was taken by the board. It wasn't a directive by the superintendent telling all 4 of y'all to say you've got to approve her. This was something each of y'all decided on your own as far as the position she would occupy. So the grievance, if anything, is against the board as opposed to the superintendent in putting her in that position. The next thing that you have to look at is with regards to the failure to state a claim. Her allegation in here as far as the basis of the complaint is a violation of Standard 10 of the Code of Ethics of the Professional Standards Commission. In that, it specifically states, if you're alleging a violation, that it's an educator shall demonstrate conduct that follows generally recognized professional standards and preserves the dignity and integrity of the teaching profession. Unethical conduct includes, but is not limited to, any conduct that impairs or diminishes the certificate holder's ability to function professionally in his or her employment. None of that is the case. None of that is alleged in her grievance form. Nothing that falls within the scope of Standard 10 of the Code of Ethics. Her entire complaint gives you general and unsupported allegations in which she states, it's my belief of retaliatory conduct. Nothing within the scope of Standard 10 of the Code of Ethics. Next, you have to look at the fact that there's been no action by the board or the superintendent or associate superintendent since October to modify the job description. It's the same one that's been in place since October of last year. Finally, you've got to look, or not finally, but another thing is waiver. You've got to consider whether she's waived any of her rights. She stated in her own letter, that's also attached, of February the 19th, which the board had a copy of, in which she requested the opportunity to speak to the board. She sent a letter, first of all, to the superintendent, and then to the chairman, and said, I'd like the opportunity to come in and speak to the board. And the chairman responded and said, we can't do that. If you want to handle this matter, file a grievance. That's how you need to proceed, file a grievance. And that was done back in February the 19th. Again, going back to the 10-day period, untimely. She waived any right she has to be here today to call any witnesses to testify on her behalf, to present any type of claim against the Humphreys, because she's waived that right. The chairman noted specifically, if you want to pursue this, file a grievance. She said, I don't want to file a grievance. That would have had to have been done within 10 days in order to make this hearing necessary today. 10 days. Next, you've got to look at due process and equal protection. In this particular case, is the board going to say, let's make an exception for Ms. Strickland? Rules don't apply to her. We don't have to follow the policy. We don't have to follow the 10-day requirement that's set forth for all other employees. Let's just avoid that. Let's just ignore our own rules and regulations. It demonstrates this grievance must be dismissed. We don't need to call the first witness. It's untimely. She's occupied the position of associate superintendent. She needs to know these rules and regulations better than anybody. And clearly she said, as evidenced in her conversation with the chairman in the past, I don't want to file a grievance. But now, months later, outside the scope of the 10 days, it's clearly untimely. And the only logical recourse for the board to take at this point in time is say, grievance dismissed. We deny your grievance, it's time to move on. The evidence is overwhelming. That vote needs to be taken before any consideration is made. Thank you.
And let me just get for the record, I've marked, I'll get the sticker to make sure it's a little bit clearer, but as far as the record itself, I'm going to mark this complaint, that's the basis of this hearing, as Exhibit R1. This is just a record exhibit. It's not evidence itself. This that's being presented to you, but just an exhibit of why we're here, what the allegations are. And I'm also going to have Exhibit R2, which is a copy of the board's complaints and grievances procedure, which is under descriptor code GAE2. So that'll be part of the record. I just want to make sure everybody was clear about that. And I may have a few questions, but Mr. West, you want to respond? I think Mr.
Yeah.
Wilson brought up several points as far as the basis for the hearing and whether it should be dismissed.
As Mr. Calhoun, that was a brilliant legal argument. However, it was wrong. One point, let me just sort of take them with regard to the failure to state a claim. Miss Strickland, one, it was timely because she didn't get actual written notice until May the 3rd. And the board's policy, the board has a written policy for the purpose that sets out when exactly the procedure that should be followed. And essentially what the superintendent has done in sending the reassignment of her position is he has essentially demoted her. And I would draw your attention to board policy administrative personnel transfer. It's the descriptor code is CGL, and I'll provide a copy of that to you folks for your convenience. See, I don't know if I have enough of them to go around. If you look on paragraph 2 there, it says that the motion is defined as a transfer of job with less pay, less responsibility, and less prestige in the community. All three characteristics must be present before a demotion has taken place. When the superintendent or board proposes to demote a certificated employee who will be completing no more than 3 years successive service with this board, written notice of such intention to demote shall be given by not later than April 15 prior to the year in which the demotion would take place. And I guess the respondents, Mr. Wilson's clients, have admitted that in their motion that it wasn't until May the 3rd that notification was sent out, clearly after the April 15th deadline. Now, what the basis of what Ms. Strickland's grievance is that over at least the past year, and I don't want to get too far into what our next phase of our argument will be, but just for the purposes of this motion, over the past year, the behaviors towards her and potentially others in the office has created an environment that has been created a hostile work environment, and which has incident after incident has led up finally to her being demoted through this written notification on May the 3rd. Provided to her on May the 3rd, written on May the 1st. And furthermore, Ms. Strickland filed a timely grievance within the 10 days of May 3rd on May 7th, which also the respondent has admitted in their motion to dismiss. And with that, that's all the comments I have to draw to the motion.
This policy seems to be really a reference to State Fair Dismissal Act, aside from the dates that have been changed more recently in state law since this policy was written.
It's taken from the Board of Education of Lanier County's website under their policies, under board policies.
Correct, yeah. But it certainly has a reference to providing a hearing in accordance with state law. State law requires, the Fair Dismissal Act requires these notices by May 15th.
Well, she's not being dismissed, she's being demoted.
Or for a demotion, and let me, is this supposed to be, I don't know if this is.
It's not
intended to be
that
part of the grievance itself, but the demotion of an employee is not subject to this grievance process, so.
Well, in other words, her grievance of being a violation of Code of Conduct Standard 10 this is the precipice that has finally led up to, all the events have finally led up to this. Which she will testify to.
Can I comment on the demotion aspect when you finish?
Well, let me bring up one other issue that I don't think is raised here, but at least for the record, the other, looking at this, I have a concern with whether standard 10 of the Code of Ethics can even, or frankly, any provision of the Code of Ethics can form the basis of one of these grievance hearings. And the basis for that is this process only applies to an employee, a certificated employee affected in their employment relationship by a claimed or alleged violation, misinterpretation, or misapplication of statutes, policies, rules, regulations, or written agreements of the school system, or with which the school system is required to comply.
What
The Code of
provisions
Ethics,
are there?
this is from
What policy?
or policy GAE 2. It's also the requisite statute, but Code of Ethics applies to individual certificate holders, not to the school district.
Certainly.
And so that would seem to be outside of the scope of this process
Well, I think
that forms the basis of this hearing.
I think what Ms. Strickland is citing is that she has been subject to a hostile work environment from to employees, which she has filed a grievance, taking the necessary and proper administrative procedures, and providing evidence. She provided a written reason, one of which being a violation of Standard 10, but there are certainly others.
Mr. Wilson, you respond to the motion
Right.
issue?
Mr. Smith, I'm sure you're well familiar with the fact that you probably have never seen a case in the State Board of Education which involves a demotion where it is requested by the employee. It is something which is adverse, which the employee is contesting and never requests on their own, which requires the loss of prestige, responsibility, and pay. And oftentimes you might have a slow motion demotion where those three events occur over 2 years. But here, when you have an employee who comes in and makes the request to be transferred to another position and resign her position, does not fall within the scope of being a demotion. It is when the school district tells them, we are demoting you from this position to a lower level position, and it is an involuntary move. It is not something that is initiated by the employee. It is initiated by the school district, and this school board is well aware of the fact that there was no recommendation by the superintendent that Ms. Strickland be demoted. It initiated of her own free will and request to this board to transfer her to the instructional lead teacher's position. And therefore, this clearly falls outside the scope of demotion and is not subject to a hearing today. And again, reiterating the fact that we feel the cause of action that she's contending as far as this grievance proceeding clearly does not meet the legal tests and requirements that the statute intends to require.
Mr. Hearing Officer, if I may respond.
Yeah.
She initially requested a transfer. She did not request a diminishing amount in any of her benefits. She did not request a diminished amount in her salary. She only requested to get out of a hostile work environment and transfer. Clearly not a demotion.
I mean, I think it's clear that the demotion under the Fair Dismissal Act, which is what this is a reference to, would be something that's not grievable. I mean, it's clearly excluded under the policy. As far as this motion, and for the record, I've marked these two motions, exhibits R3 and R4 for the record. The motion to disqualify is R3 and the motion to dismiss is R4. I'm going to reserve motion on the motion to dismiss and at least wait and may frankly not rule on it at all, but want to get into the hearing itself. The board may decide at the end of the day this is not subject to the grievance process, that this was filed too late, or any of the number of other things, or if they stop any time before we get to the end of the day. in the end of this hearing that may occur, but I'm going to hold judgment on that. I frankly would like to hear some of the actual evidence that may establish some of these issues and may end up in a dismissal by the end of the hearing. Frankly, I think the complaint itself, I think Mr. Wilson raises some very serious issues of whether this was timely filed and whether or not this the claims are even subject to this grievance procedure. But with that reservation, we'll move forward unless there's any other preliminary matters from either side.
Well, as far as the timeliness of it, as you're aware, Ms. Smith, we did not have any type of pretrial hearing or conference prior to this afternoon. In 30 years, I've never had a pretrial conference prior to an adversarial hearing with a school board. So as far as that argument, I submit it does not carry any weight there because this is a short-term matter and they're traditionally held on the night of the hearing as opposed to a trial where you're before the judge weeks in advance. And I guess the second thing I would respectfully request, that the hearing officer allow at least poll the board members to determine whether or not they are inclined to go ahead and grant the motion at this point in time, and based on the facts that have been argued before them and their knowledge of the policies of the Board of Education, at least allow them maybe go in executive session to deliberate on that particular point before we possibly waste additional time of everyone here, if that's the inclination of the board members who will be casting the votes on this issue.
I would object to that procedure, and I think the hearing officer is going to make a ruling on the motion and perhaps make it impartial.
And I'm not gonna, I don't think I'm gonna win a written argument on this particular issue. Like I said, I'm inclined to just proceed with the hearing right now. May change my mind by the end of it, may decide we're gonna stop the hearing and it's over, and dismiss. And like I mentioned before, if any board member wants to make a motion to discuss or approve the dismissal motion, we can do that at any time. Just let me know, but unless until that happens, we'll just proceed forward with getting into some of the actual evidence itself and see where that leads. So this time, unless there's any other preliminary issues, we'll begin with Mr. West and your presentation on behalf of Ms. Strickland and your witnesses as far as this particular grievance.
Thank you, sir. Well, just for your folks' knowledge, I'm going to have an opening statement and then with testimony from Ms. Strickland. We won't be calling any other witnesses except Ms. Strickland. Ms. Strickland is here today to express a grievance as to her work environment brought about due to working relationships between the professional staff at the Board of Education. Specifically, we have presented evidence to show that she has faced a hostile work environment due to nepotism that exists between the superintendent, Steve Humphrey, and Ms. Strickland's counterpart, Associate Superintendent Kathy Humphrey. As you know, the Humphreys are husband and wife. You will be presented evidence that indicates Ms. Strickland's work environment has deteriorated over the past year to the point that program services are at risk. This culminated in Ms. Strickland requesting a transfer in February, and finally the letter which we discussed, what we argue is a demotion in her position. The board took up Ms. Strickland's employment upon her suggestion of a transfer, you may recall, and the motion died for lack of a second. It was brought up again by the superintendent, Mr. Humphrey, that she be reassigned as an instructional lead teacher. And it was, again, not till May 3rd that Ms. Strickland received notification of the proposed reassignment, with a proposed new contract and new job description. We expect the evidence may show Ms. Strickland has been assigned different positions and roles over the past couple of years to effectively shield the Humphreys from others in the community or on the board from questioning the appropriateness of the duties and the compensation of Mrs. Humphreys. We expect the evidence will show that a strained and dysfunctional work environment has resulted from the familial relationships between the senior staff, resulting in conflicts between the parties in the office, and essentially putting the education programs at risk. Next, we expect evidence will indicate that the superintendent's recommendation of the board change Ms. Strickland's employment assignment has essentially resulted in a demotion as indicated by the policy that you referenced earlier. No matter whether Mr. Humphrey's recommendation is well-intended or retaliatory, the effect of the reassignment has been a demotion, the implementation of which, the procedures of how that went about, and the timeliness of it being after the April 15th deadline is not in keeping with the board's own stated policy. And finally, I expect Ms. Strickland will encourage the board to consider enacting a nepotism policy going forward to protect the integrity of the education system here in Lanier County. At this time, I'll call Ms.